Hamilton University of Science and Technology. So today's last panel, as I indicated earlier, is on the judiciary under the 1992 Constitution. Our first speaker, Mrs. Susanna Futi, will be talking, Prosper, we'll go first. Yes, Prosper will be talking about the Supreme Court's mandate of tempering executive power in Ghana under the Fourth Republican Constitution. And then Justice Dr. Shamsai and Alenga will talk about when your only tool is a hammer, examining the exercise of the referral jurisdiction of the Supreme Court over 30 years. And then finally, Mrs. Susanna Futi will talk about the acquisition and proof of citizenship in Ghana, an appraisal of the law. And then after that, we'll have the closing reflections, and the conference will come to an end later on in the afternoon. So with a round of applause, let's welcome Prosper to give his presentation.
Dean Moderator, with your permission, I would like to stand on existing protocol. Greetings and happy third anniversary. I'm speaking to the topic, the Supreme Court mandate of tempering executive power in Ghana under the Fourth Republic. The 1992 Constitution of Ghana ushered in the Fourth Republic, offering the nation the opportunity to begin de novo is in realizing its goals, aspirations, and ideals of attaining abundance and escaping poverty in free and peaceful Ghana. The preamble to this constitution directly states the rule of law as one of the principal anchors around which the rest of the constitution draws its pulse and drive. When distilled to its essence, the rule of law strongly mandates that the exercise of power be tempered to avoid abuse. A rule of law political community does put in place guardrails that temper those who exercise power, both public and private. Various organs and individuals under the Constitution are tasked with tempering the exercise of power in Ghana. The Supreme Court of Ghana, however, is the bellwether of the institution that temper power in our country. Tempering power is such a key mandate of the Supreme Court. The court under the Constitution has the power to validate or invalidate acts and omissions of entities and individuals in respect of the Constitution. No other court or organ or state shares this enormous power and mandate with the Supreme Court. And citizens of Ghana, aware of this power and duty of the court, have had occasion to invoke the jurisdiction of the court to uphold the rule of law, and the court in turn has been utterly eager to execute its rule of law constitutional duties when properly invoked. But very little extensive scholarly legal research, if any at all, has been conducted on the Supreme Court's rule of law power tempering mandate. In fact, the literature suggests that no more than 2 comprehensive works solely dedicated to Ghana's Supreme Court are available. This dearth of scholarly and reflective literature on the court's rule of law mandate and its impact on Ghana's development is unsettling, given the unique role and place of the court in our national life. This void that the legal scholars have not comprehensively evaluated the role of the performance of the court, especially its singular and crucial task of tempering the power of those who exercise power on behalf of the state, is unsettling for another reason. Within 3 years after the new constitution became operational, calls for its amendment and even its outward population began. These calls to amend certain provisions of the constitution continue to be made as the constitution enters its third anniversary this year. Yet legal scholars have not yet evaluated the single most important duty of the court, how it safeguards the Constitution by tempering the exercise of power not found in the Constitution. I offer to fill this void today. To put this evaluative exercise of how the court has tempered the power of the executive in context, I'll begin with two brief preliminary sections: the importance of preambles and the jurisdiction of the Supreme Court of Ghana. Preambles or prefatory clauses to national constitutions are important, as they often and intentionally frame and guide the meaning and operation of the main text of the Constitution. This is how the first country to adopt a written constitution that has endured today ratified that constitution. The public ratification process began in earnest when the Constitution was first presented to the American people in the Philadelphia newspapers. It was front-page news. The preamble was said conspicuously in very large font, while the rest of the Constitution was a fine print. Within weeks, the Constitution was printed as a 16-page pamphlet, again with the preamble prominently typeset as a title page, followed by the text of the Constitution body, set in smaller, regular type. Thus, from the beginning, the public perception of the Constitution was captured by the preamble. It bodily epitomized what the Constitution promised to deliver. Accordingly, one might well wonder, was it a preamble, more than anything else, that finally took the voters' skills and secured the successful adoption of the Constitution? The preamble to Ghana's fourth Republican Constitution unambiguously and boldly pronounces various core director of the rule of law, among them freedom, justice, probity, accountability, sovereignty, and of course, human rights. Therefore, the sowing, watering, growing, sustaining, and protecting and promoting the rule of law as the holy grail of Ghana's development is the unifying and cross-cutting and intersecting jurisdiction of the Supreme Court of Ghana. Ghana's Supreme Court, the nation's main gateway of the rule of law, therefore may be judged to pass its test of protecting and fortifying the rule of law if its pronouncement, judgment, orders, opinions evidently temper the powers of the three arms of government as well as the state actors. The Supreme Court is aware of its expected power tampering task, a duty that flows from the Constitution. Hence, Justice Ajabin, in his dissenting opinion in the case of Amidu, President before, for example, writes that our 19th Constitution has firmly established the rule of law in the country, which means, he explains, that everyone in this country, including His Excellency the President, is under the Constitution and the law. And the unifying importance and goals of fulfilling the perpetual exercise of executive power, he further asks that adhere to the policy will indeed bring about real democracy and therefore freedom and justice. Leaving power in the hands of one person or one set of persons had a natural tendency to breed despotism and tyrannical rule because of the fallibility of man. It's how Justice A.P.K. Kuge thinks the importance of tempering the power of government, especially executive power. And Justice Francis Pega, in the case of YEBOAH versus J.H. Mason, emphasizes that one of the criminal functions of the Supreme Court, apart from adjudicating constitutional matters, is promoting and safeguarding constitutional values. I now turn to how the court has tempered power. But to avoid running in my speech, I will just summarize because the moderator has told me that time is not our best friend today. Executive power is very broad. It's covered the powers exercised by the president, his ministers, and then his subordinates. Therefore, even apart from the president, those who exercise such powers are exercising executive powers. I will go through some of the cases that have tempered the tempering of this power. To start with, we have to answer the question whether even the president can be sued in court. And in the cases of New Patriotic Party versus President Rawlings, the court said, no, the president cannot be sued personally in terms when he exercises executive power. The reason is that it's not that the president is above the law, not at all, but it's because they want to preserve the respectability and order around the president. Justice Amoseki, in saying that the president cannot be personally sued, but can be sued through the Attorney General, had this to say. Although the president is the first citizen, he's not above the law. The medieval fiction that the king can do no wrong, which the sophists interpreted to mean that if the action was wrong, then it was not that of the king, has no place in the republican setting, which prides itself on all citizens being equal under the law and therefore obliged to act in conformity with it. We recognize that the executive president, being the most powerful person in the state, is the one who has the greater capacity for wrongdoing. So the president can be sued, but through, the attorney general. And in fact, when the president leaves office, within 3 years, you can sue him if he breached a contract with you while he was in office. But after 3 years, after he leaves office, if you don't sue, probably the statute of limitation will have taken. The other case had to do with the IGP. In the case of YEBOAH versus Attorney General, the IGP at the time asked 2 police officers to retire compulsory. They were 55 years old at the time. Probably he knew of their real age and they were presenting their full age, but he asked them to retire. So they went to court and sued the IGP. The court held that no, the IGP cannot ask police officers without much to retire when they are only 55. And the Constitution says that they should retire at the age of 60. And in the case of New Patriotic Party versus Attorney General, the 31st December case, as we all remember, Rawlings wanted to declare 31st December and June 4th as public holiday. And because of the spirit of our Constitution, we are against coup d'etat. The court held that no. Those 2 days, because of their connection with coups, cannot be declared public holidays to be celebrated with public funds. And this will affront our efforts at good governance and our quick attempt at forgetting coup d'etat and making sure that they don't happen. Let me conclude quickly, for the sake of time, what I consider to be the most important part of my presentation here. In all of these cases, the court has indeed tempered the power of the executive, but has that promoted democracy and good governance? Farid Zakaria, in what is becoming a canonical piece over 2 decades after it first appeared in print, titled The Rise of Illiberal Democracy, wrote of government elected or even re-elected, routinely ignoring constitutional limits on their power and depriving their citizens of basic freedom. Farid called this kind of government illiberal democracy. And I'm confronting the question now as to whether Ghana is an illiberal democracy. The only credential of democracy, illiberal democracy, is their insignia of being elected by the people. Up until Farid reintroduced and popularized the term illiberal democracy, democracy largely meant liberal democracy. A political system marked not only by free and fair elections, but also the rule of law, the separation of powers, and the process of basic liberties of speech, assembly, religion, and property. Historically, as Farid explained, democracy has not been synonymous with illiberal democracy. Liberalism, either as a conception of political liberty or as a doctrine about economic policy, may have coincided with the rise of democracy, but it has never been immutable or unambiguously linked to the practice. When Farid wrote his piece in 1997, this is what he thought about Ghana, whether Ghana was a liberal democracy or an illiberal democracy. He said this: despite the limited political choice they offer, countries like Singapore, Malaysia, and Thailand provide a better environment for the life, liberty, and happiness of their citizens than do either dictatorships like Iran or Libya, or illiberal democracy like Slovakia or Ghana. So in 1997, he said Ghana was an illiberal democracy. Probably, we would not have argued much with Farid's labeling of Ghana as an illiberal democracy in 1997. Ghana had just transitioned from a military regime about 4 years earlier. Ghana had just adopted its new constitution about 4 years earlier. Ghana has just held its first multi-party election about 4 years earlier. And Ghana was about a 4-year-old republic in 1997. But this is 2023. Over 2 decades after Farid called Ghana an illiberal democracy, one wonders how Farid would describe Ghana's democracy today, and that one is not too sure how he would describe our democracy is troubling and telling. And the Supreme Court has a lot of work to do, and so do all of us. Thank you very much.
Thank you very much, Prosper Batingi, for that presentation. And I'm sure we have questions for you. I have some questions that I would like to ask you once we are done. So let's move on to our second presentation. Mrs. Susanna Futu will be speaking on the acquisition and proof of citizenship in Ghana, an appraisal of the law, and she will be doing a PowerPoint presentation. So I think everything has been set up. Do you want to come here? You want to come?
So I'm here to speak on the acquisition and proof of citizenship in Ghana. So citizenship has been defined by the Free Legal Dictionary as the legal link between an individual and a state or territory, as a result of which the individual is entitled to certain protection, rights and privileges, and subject to certain obligations and allegiance. There are various ways of acquiring citizenship in Ghana. It can be by birth, by adoption, by registration, or by naturalization. Article 6 of the Constitution of Ghana and Section 1 of Act 591, which is the Citizenship Act, enables people who were citizens in Ghana before the commencement of the 1992 Constitution to continue to enjoy their citizenship status. For the sake of clarity, Sections 1 to 6 of Act 591 restates the various citizenship regimes under the past government of Ghana. So we'll start by looking at citizenship by birth and what the law has to say on that. Article 6.2 of the Constitution states that a person born in or outside Ghana after the coming into force of the Constitution shall become a citizen of Ghana at the date of his birth if either of his parents or grandparents is or was a citizen of Ghana. Clause 3 provides a child of no more than 7 years whose parents are not known shall be presumed to be a citizen of Ghana by birth, and a child of a different nationality who is less than 16 years of age and is adopted by a Ghanaian or by Ghanaians shall be deemed to be a citizen by adoption. We're moving next to citizenship by registration. This is provided for by Article 7 of the Constitution and Sections 10 to 12 and Section 15 of Act 591, the Citizenship Act. This applies to persons married to Ghanaian citizens and other persons seeking to be Ghanaians by registration independent of marriage. Such persons shall satisfy the Minister of Interior of conditions such as being of good character, being ordinarily resident in Ghana, and ability to speak and understand an indigenous Ghanaian language. We're looking next at what the law has to say on citizenship by naturalization, and that is covered by Sections 13 to 15 of Act 591. And this tells us that the Minister for Interior may, with the approval of the President, grant a certificate of naturalization to certain persons of age and capacity if they satisfy the conditions stated in the Act, and such persons shall be required to take the oath of allegiance and become a Ghanaian citizen from the date on which the oath is taken. And some of these conditions, when you check the Act, has to do with the ability to speak a Ghanaian language, the term of your residency, etc. And the Act further tells us that the minister, in other special circumstances, as he thinks fit, and with the approval of the President, may modify, vary, or waive any one of the qualifications for naturalization set out in Section 14 of the Act, except the qualification specified in subsection 1E of this section, which is the ability to speak and understand an indigenous Ghanaian language. We're moving next to the proof of citizenship in Ghana and how this is determined by the law. And we'll be looking at Section 21 of Act 591. It tells us that citizenship status can be proved by a birth certificate, which would provide, as we know, information on the nationality of one's parents, and this is proof of citizenship by birth. It can also be proved by a publication in the Gazette. We can see that in Section 15 of Act 591. A certificate of citizenship for those applying for dual citizenship, we can see that in Section 16 of the Act. And Section 21 of the Act tells us that a notice, certificate, an order or declaration or entry in the register or subscription to an oath of allegiance given, granted, or made under Act 591 shall be used in proof of evidence. And further, Section 21 informs us that evidence can be either by a certified true copy or an order in a register. In the case, so we're going next to look at decided cases. In the case of Bruce versus the Attorney General, a rather old decision, it was held that the production of the plaintiff's passport and baptismal certificate was good proof of his nationality, and it was held that he had not lost his nationality. In Olympio versus Commissioner for the Interior, the plaintiff was able to establish that he had a Gold Coast passport and that both of his parents were born in Ghana. Now, it's a more recent decision. One of the issues decided by the Supreme Court in the case of the National Democratic Congress versus the AG, the consolidated writ of the National Democratic Congress versus the AG, and the Electoral Commission of Ghana and Mark Teshi Benson versus the EC and the AG. One of the issues held in this case was whether it was constitutional for a birth certificate to be excluded as a means of identification under CI 126, which was the constitutional instrument put forward by the EC on voter identification. With regards to this, the Apex Court noted that a birth certificate was never a means of establishing identity, and that the the prior CI 72 or CI 91, and that to adopt it as a means of doing so was retrograde. The court held as follows, and it was a unanimous decision given by Justice Ashini Ashikote, and he said a birth certificate is not a form of identification. It does not establish the identity of the bearer, nor does it link the holder with information on the certificate. Quite obviously, it provides no evidence of citizenship. It therefore does not satisfy the requirements of Article 42 of the Constitution. In fact, as a form of identification, it is worse than the NHI card, which was held to be unconstitutional as evidence of identification of a person who applies for registration as a voter in Abu Ramadan number 1 and number 2. With all due respect to our law lords, I find the foregoing conclusion of the Apex Court on the authenticity of the birth certificate as proof of citizenship to be very worrying on two counts. Firstly, Section 21, as we have seen, which has been referred to, states that citizenship status can be proved either by a notice, a certificate, an order or declaration, or an entry in a register, or a subscription to an oath of allegiance given, granted, or made under the Citizenship Act. Further, Section 25(3) of Act 591 is a savings provision which continues in force all acts taken under the Ghana Nationality Act 1971, Act 361, which has now been repealed. Secondly, it is notable that a birth certificate is tendered in as proof of citizenship when one desires to procure a passport or a national identification card, both of which are seen as valid means of proving identity under CI 126. Though the birth certificate does not provide a picture, it provides on the face of it information on the bearer's nationality, name of father, and maiden name of the mother. In the case of Captain versus Minister for the Interior, the plaintiff had put in an application for citizenship by naturalization. The plaintiff was Lebanese and had put in an application for citizenship by naturalization. In the course of his application, his residence permit was withdrawn. On a reference to the Supreme Court, it was held that no reasons had to be proffered for the refusal. Captain was even issued with a presidential decree, which was a requirement for the grant of naturalization, and the High Court QCJ held that he had to leave the country as his residence permit had been withdrawn. And we'll be coming back to look at the issue in the Captain case very soon. So we will be concluding with the issue of, or the use of discretionary power by administrative officials. A discussion on citizenship is not complete without the mention of the use of discretionary power by administrative officials. With the exception of citizenship by birth, citizenship by adoption, registration, and naturalization involves the discretion of the Minister of Interior. It is clear that discretionary power must be properly exercised. Article 23 of the Constitution provides that administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. The standard of reasonableness to be applied by administrative officials has been given in cases such as Associated Professional Picture House versus Wensby Corporation. In this case, the English court concluded that the defendants had taken into consideration that which they had to take into consideration, and that they had not been swayed by extraneous matters, and as such their decision was valid. Article 296 also provides that where in this Constitution or in any other law discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law, and where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instruments or statutory instruments regulations that are not inconsistent with the provisions of this Constitution or the other law to govern the exercise of the discretionary power. The Court of Appeal, sitting as the Supreme Court in the Captain case, held that with regards to Article 296, which was in the 1979 Constitution, Article 173, which we'll come to, they held that a distinction had to be made between administrative decisions of a judicial nature or quasi-judicial nature, which could be subject to judicial review, and those which could not. Professor Jandor, the late Professor Jandor of blessed memory, and his treatise, Discretionary Powers in the Second Republic, remarked that the Supreme Court in the Captain case erred in making this distinction between administrative actions of a judicial or quasi-judicial nature, which must follow due process, and those which are not subject to such. He arrived at that conclusion by analyzing the cases of Cooper versus the Wandsworth Board of Works, the Strinish case, and the Rich versus Baldwin, all of which are English cases. However, this provision that was being analyzed in the Captain case was Article 173 of the 1969 Constitution, which is similar to Article 296 of the 1992 Constitution. With regards to Article 173, the memorandum to the proposals for the 1969 Constitution notes as follows. When discretionary power is given to any person or authority, that person or authority should publish a statutory instrument which will set out the principles, the manner, and the mode of the exercise of the discretionary power conferred. I agree with Professor Jando that the distinction made by the apex courts in the Captain case between administrative actions of a judicial or quasi-judicial nature and those which fall outside of this purview is unnecessary and only makes room for arbitrary and capricious behavior by administrative officials. It is noteworthy that the decision in Captain has been upheld by the apex court in the Fourth Republic in cases such as Ransford France versus the EC, Afoko versus the Attorney General, and Agbamaba YEBOAH Bidietu versus the AG. In the case of National Democratic Congress versus the AG and the EC, and Mark Techi Benson versus the EC and the AG, this case was centered on the constitutionality of CI 126. In summary, the Supreme Court held that the EC had not abused their discretionary power and that it was constitutional for the birth certificate and the voter identification card at the time to be excluded as means of identification of voters. It is notable that there is currently before Parliament a constitutional instrument put forward by the EC that seeks to make the Ghana identification card the only source of identification for a Ghanaian who seeks to obtain a voter's card. What's more, this instrument disqualifies the guarantee procedure in the procurement of such a card and also excludes a passport. This is such a curious position, as the guarantor procedure and the national passport are both means of procuring a Ghana identification card. It is my view that we owe it to our country to ascribe to Article 296 a purposive interpretation that enables us to secure for ourselves and posterity justice, probity, and accountability from public officials. The Supreme Court of Ghana can, under Article 1293 of the Constitution, depart from a previous decision when it seems right to do so. It's my prayer that, given another opportunity to examine Article 296 of the Constitution, the apex courts will depart from the ratio in Captain, which has been upheld in Ransford France, in Afoko, in Agbamaba YEBOAH Bidietu versus the AG. Respectfully submitted. Thank you.
Thank you, Mrs. Susanna Afutu, for your presentation on proof of citizenship in Ghana and appraisal of the law. And I must say that you have done an excellent work, and I have some questions for you. So you should get ready for that. So we'll go to a final presentation, which is a joint presentation by Dr. Justice Remsai and Mr. Cletus Alenga, and their topic is when your only tool is a hammer. When your only tool is a hammer. Examining the exercise of the referral jurisdiction of the Supreme Court over 30 years. So let's welcome Cletus for this presentation.
So good morning. Justice and I are seeking to examine the referral jurisdiction of the Supreme Court and the discretionary power or otherwise of courts below the Supreme Court in referring matters to the Supreme Court. Now, it will appear from our research that the only tool in the hands of all these courts, including the Supreme Court, has been a hammer, and that hammer is interpretation. And so anytime this issue arises, the court looks at it from an interpretation point of view rather than the other jurisdictions conferred on the court under Article 131 and 2. And now, and so if you look at Article 2.1 and 131, they vest the Supreme Court with original jurisdiction in some matters. Now, in the case of Badema and Awolo Williams, these were the three heads of jurisdiction that the court said the Supreme Court exercises its original jurisdiction. Now, it is important that I pick this from 1969 because the root of Article 2.1 and the 131 are from the 1969 Constitution. In the 1960 Constitution, the Supreme Court had original jurisdiction only in respect of excess of the powers of Parliament. So when an enactment is in excess of the powers conferred on Parliament, that was the only time the Supreme Court has original jurisdiction. There was no original jurisdiction in respect of interpretation or enforcement. This was first introduced in the 1969 Constitution. And what we have today is just a reproduction of the 1969 Constitution. And this is what the court said, that in these three instances, interpretation, enforcement, and any question relating to whether the enactment is in excess of the powers conferred on Parliament or any other authority for that matter. So these are three distinct issues that any of the heads of the Supreme Court's original jurisdiction, original interpretation will arise. Now, fast forward, move to the next slide. This provision was repeated in the 1979 Constitution. However, when the court had the opportunity to pronounce on this, this appeared to have combined the interpretation jurisdiction and the enforcement jurisdiction of the court together. And so if you look at this quotation from the oft-quoted case, Republic versus Special Tribunal Espata Kosa, this appears to have become the locus classicus of what is a question for interpretation. And if you look at it from that angle, it is right. When the words used are imprecise, when there's ambiguity, when the parties are putting different interpretation on a particular provision, on a particular word, all those ones are correct for interpretation. But if you look at what the court said that they will conclude that the issue of enforcement or interpretation. And so in the view of the court, these matters are not only in respect of the interpretation jurisdiction of the court, but also in respect of the enforcement jurisdiction of the court. But if you look at all the four items they listed, none of them specifically actually speaks to a question of enforcement or even the other head, whether an enactment is said to be in excess of the Supreme Court, of Parliament's powers or any other authority for that matter. So this was the conclusion of the court in the Espata Akusa case, that there is no case of enforcement or interpretation. And I've intentionally highlighted the two words, enforcement or interpretation, because they put the two together, make it appear as if the two, the enforcement jurisdiction and the interpretation jurisdiction, are the same. Now, even under our 1992 Constitution, the court, and in fact the Supreme Court, appears to have fallen under that same apprehension. And this is what the court said in Osei-Boating. Fortunately, the Osei-Boating case has been overridden by court and Attorney General, but I just wanted to bring it up and say that even the Supreme Court still thought at certain point in time that their enforcement jurisdiction and interpretation jurisdiction are combined. And so that the bar says that there is no question of enforcement or there is no question of interpretation. And so if the words are clear, even if there is a breach, still go back to the High Court and don't come to the Supreme Court. And so for the court, there was no distinction between enforcement and interpretation, and that is where the problem arises. And so you will realize that anytime these issues come before the court, anytime a question of whether a matter should be referred to the Supreme Court arises before any of the lower courts, the High Court, the Court of Appeal, or for that matter, the analysis of everything that the court does is whether the words used are imprecise. It's whether there's an ambiguity in the words used. It's whether the parties are putting rivalry meanings onto the words or onto a particular provision of the Constitution. But that is not the intendment of Article 132. Now, if you look at Article 132 and then just oppose it Article 131, what it means is that the three heads of jurisdiction, which was pronounced in Auru Williams, enforcement, interpretation, and ultra vires, whether the enactment is in ultra vires, Parliament, or any other authority for that matter. Any of these three issues give rise to an application of Article 132, and for that matter, the original jurisdiction of the Supreme Court. It is very wrong for all the three to be tied into interpretation and explained only in terms of ex parte acquisa. Yes, there is the need to avoid frivolous referrals to the Supreme Court. No doubt about that. But in seeking to avoid frivolous referrals, it is also important to respect the jurisdiction of the Supreme Court and not to usurp the jurisdiction of the Supreme Court. And so it is important that the three issues are taken separately in any matter that comes before any court for that matter. Now, if you look at the issue when it comes to referral in respect of interpretation, go to the next slide. When it comes to referral in respect of interpretation, the ex parte acquisa case is a very good case to analyze whether there's a genuine case to refer to the Supreme Court. There's no two ways about that, because it's still good law in our view in respect of whether there's a question of interpretation. And so if the question that arises before a lower court is in respect of interpretation of a particular provision of the Constitution, because of the need to prevent frivolous referrals to the Supreme Court, it is important to assess the case and the merits of the case on the ex parte acquisa case. And indeed, the obiter in my can tells us that if the words are clear, just apply it, and you need not make any referral. But even that, now that the courts have moved towards what is called the model purposive interpretation, it is even not easy to say on the face of the provision that the words are clear, because the words may be clear, but if you adopt the model purposive interpretation, you may end up elsewhere. And so there is, even in doing that, there is the need to be very cautious of how the analysis is done. And that is why the Supreme Court itself, in Court and Attorney General, says the duty imposed on courts below the Supreme Court to refer questions of interpretation to the Supreme Court is not an inflexible duty. In other words, once you are faced with a question which appears interpretative, you must refer the matter to the Supreme Court. In the Republic versus ex parte Shraj, the court said that it is important for other courts not to presume that the words are clear. And the danger there is, if you presume the words are clear, then you apply it, you may end up interpreting. But then again, the caution always is also to ensure that you prevent frivolous referrals to the Supreme Court. And that is why, in our view, the ex parte acquisa case is a very good case when it comes to interpretation, even though that discretion ought to exercise very cautiously in order not to usurp the jurisdiction of the Supreme Court. It is a very good test to analyze it. However, when it comes to issues of enforcement, it is our view that ex parte acquisa is inapplicable at any case. Ex parte acquisa deals with interpretation, and as I've already pointed out, the position now which the Supreme Court now agrees is that the interpretation jurisdiction is separate and distinct from the enforcement jurisdiction. And so if the matter is only an issue of enforcement and not interpretation, ex parte acquisa is not applicable. In the same vein, if the question arises as to whether an enactment has been made ultra vires Parliament or any other authority for that matter, ex parte acquisa is inapplicable. Now, in both instances, because the enforcement jurisdiction of the court actually ties in to whether an enactment has made ultra vires Parliament or any other authority. In both instances, if it is posited that a session or a particular session of a particular enactment is contrary to a provision in the Constitution, and the High Court determines that it is not contrary, or if the question is Parliament exceeded its powers when it enacted, say, Section 1 of the Companies Act. If the High Court determines that Parliament did not exceed its power, the High Court has, in essence, actually enforced the Constitution and interpreted the Constitution to mean that Parliament did not exceed its power. But the question as to whether Parliament exceeded this power or not can only be answered by the Supreme Court. If the question is whether a CI or an LI was made in excess of, say, the Minister for Local Government in demarcating districts, or by the Electoral Commission in making a CI and say that by removing the the passport and all other means of verification, they have exceeded their power. That question cannot be answered by the High Court. That question can only be answered by the Supreme Court. But if the High Court decides to exercise a discretion there to determine whether there is a genuine case of enforcement, the High Court will risk falling into a trap in actually enforcing the Constitution by determining the actual question that is presented before the court, which that court had no power. So there is this case which occurred in Ho for enforcement of the fundamental human rights and Article 33. The applicants had gone to court almost 1 year after the incident has happened. Then of course the obvious objection from the other side is that they are statute barred. They cannot come because the CI 47 says that you should come within 6 months after the incident that happened, and if it's continuing within 3 months, you should come. So 6 months, they are out of power. Then the argument of the applicants is, see, the power conferred on the Rules of Court Committee to make rules for the enforcement of Article 33 does not include the power to put limitations on the enforcement of that right. And so, in essence, the Rules of Court Committee exceeded its power in putting a 6 months limitation that after 6 months you cannot come to court again. Limitation is substantive. It may be argued that in some procedural matters, limitation might be procedural, but limitation can also be substantive. But to determine that question, whether the limitation in this question is substantive or procedural, and which will now lead you to answer the question whether the Rules of Court Committee exceeded its power or not, you need to refer the matter to the Supreme Court. And so counsel for the applicant makes an application for the matter to refer to the Supreme Court whether the Rules of Court Committee exceeded its power or not. And the obvious answer from the court is that this calls for no interpretation. The words of Article 33(4) are clear that the Supreme Court, the Rules of Court Committee should make rules for the enforcement of fundamental human rights. And the Rules of Court Committee has exercised its discretion in making the rules. And so you either come within 6 months or you are out of time. And that is it. That is a dangerous precedent and ought not to be upheld by the Supreme Court. Because that, in essence, is actually taking away the powers of the Supreme Court and enforcing the Constitution in that instance. That is our view on that matter. Now, another issue we are actually reviewing is how the Supreme Court has approached these instances. In most cases, when it is alleged that the High Court has exceeded its power by interpreting the Constitution or enforcing the Constitution or making a proclamation they were not supposed to make, you might find parties applying for Sharia before the Supreme Court, and then the matter will not come before the Supreme Court to determine. It appears from the review of the cases that the Supreme Court will uphold that Sharia application only if they disagree with the interpretation put on by the High Court. In most instances, what has happened is actually an usurpation of the jurisdiction of the Supreme Court. But because the court agrees with the conclusion arrived at by the lower court, they dismiss the Sharia. And so in most cases, in almost all cases where Sharia in those instances have succeeded, the court has ended up giving a different interpretation from what the High Court did. That, in our view, is also very wrong. The fact that the High Court or the Court of Appeal or the District Court or whatever court for that matter came to a right conclusion does not justify an exercise of a jurisdiction they did not have. Even if the Supreme Court agrees with the conclusion that they came to, the Supreme Court need to assume that jurisdiction in an affirmative and not just to dismiss the matter for it to appear as if the High Court had the power to do what they did. And so it is our position that, one, there is the need for the court, and in fact the Supreme Court itself, to be cautious of the differences of jurisdiction they exercise under Article 130 for interpretation, enforcement, and ultra various matters. Two, in any of those instances, the factors that may be considered are totally different from each other. And three, when it comes to questions about ultra various enactment, it is our view that the discretion of the High Court, or whichever court for that matter, is limited to almost negligible, because any attempt to pronounce on it will end you in usurping the powers of the Supreme Court. So, whereas in interpretation, and the decision interpretation is clear, because even from a model positive approach interpretation, you have to start from the ordinary meaning. And so where the ordinary meaning is clear and unambiguous, you may proceed with it. But it's where you need to move to secondary meaning. It is argued that that is where the Supreme Court's decision might come in. And so if the High Court wants to end at the original meaning or the ordinary meaning of the words, it may not be necessary to refer the matter. But if you want to move away from the ordinary meaning to a secondary meaning, then you may have to refer. However, when it comes to whether an enactment is ultra various parliament or any other authority established under the Constitution for that matter, that discretion is almost negligible, because if you exercise it, you may end up usurping the powers of the Supreme Court. And lastly, it is important for the Supreme Court to establish its authority in interpretation and enforcement of the Constitution. The fact that a lower court came to a right decision is not a justification for the exercise of the jurisdiction they did not have. And so the fact that the Supreme Court agrees with the conclusion that the lower court came to is not a justification of dismissing certiorari applications. Even if the court was right, the Supreme Court need to pronounce on it in exercise of their own powers under Article 130. Thank you very much.
I think we should give all the panelists another round of applause. So we move on to the firing squad. And as I indicated, I was, when listening to the presentation, I was taking down some notes, and I'll kickstart the Q&A session. And there's a microphone here which will be going around for questions from you, the audience, to step in. So I have one question each for you, the speakers, and I'll ask that, and then you can address them, and then we'll move on to the gallery. So, Prosper, your paper, basically, you were talking about how the Supreme Court's power to essentially temper executive power, their mandate under the Fourth Republic, it seems as if there's a void in that hasn't been done, in particular or in respect to the rule of law. It's one of the things that you touched on significantly, and you talk about the fact that there's very little scholarly research in that regard, and that this idea that, for instance, in the immediate aftermath of the coming into force of the 1992 Constitution, there began calls for its amendment, and that's a theme that has been running through this conference this past few days, and that it's your opinion that the court basically hasn't, and correct me if I'm wrong, because I'm trying to paraphrase some of the things that you're saying, the court hasn't essentially exercised this power that they have in a way that will ensure that executive power, executive authority is tempered, especially powers that are or seem to be outside the four corners of the Constitution that we have. What, in your view, why do you think, and first and foremost, is my understanding of what you're saying correct? And if it is, then what in your view has accounted for this situation, and how do you think practically we can move away from that? And if my understanding of what you're saying is not correct, then correct me and then tell us what you are proposing. So that's the question for you. Susanna, I'll ask everyone and then afterwards. Thank you for your presentation. My question to you is that what, in your opinion, should be the path that we should chart towards the 2024 general elections, parliamentary and presidential elections, in terms of having a robust voters register, for instance, in light of this Ghana card issue, and you talk about the abolition of the guarantor system and how it seems counterintuitive that if you are abolishing something, a system that you find problematic in terms of acquiring a voters register, how then does it add up that that system is already in place in terms of acquisition of the Ghana card itself, which you want to essentially use as the means by which you can acquire the voters register, which you're saying that you can use a guarantor to get the voters register. You get where I'm coming from. Yes, so that's my question to you. And my question to Cletus and Justice on your presentation on the Supreme Court and the referral power, on the issue of interpretation and enforcement mandate, and how the court itself seems to had initially boxed itself into a certain corner, a certain belief that that power that power was one and the same. You quoted just that about in the earlier case that has essentially been overruled. Do you believe that the present Supreme Court, or the Supreme Court from 1993, when the Constitution came into effect, up to this point, if you are to rate its performance in terms of this issue of when there's a referral, when the court is duly seized with the power to interpret and or enforce the Constitution, do you think the court has, there has been progress, or as in it's been worthy of our time in terms of how our constitutional democracy has progressed? Because a few weeks ago we had, and I'm asking this because a few weeks ago we had the presentation here where our friend Dr. Mensa Bonsu did a presentation, just as you were here, about how she ranked the court's decisions in terms of the ones she thought were wins and fails and things of that sort. So I want to get a sense of what you think specifically in relation to the area that you're covering about the referral powers of the Supreme Court, whether there have been wins and fails and what the proportion is, and what you would proffer, what opinions you would proffer in terms of strengthening it, because at the end of the day, that's what we're trying to do here at this conference anyway, making proposals for reform through the papers that we'll publish and all that. So those are my three questions for you. They are long, but so Prosper, we'll start with you.
Thank you for your question. Let me tease out my thesis, and then I'll answer.
So it means I got you wrong.
I won't say that. You are dean, I'm a law student. Probably after law school, I'll be looking for a job. I can't probably say you're wrong.
No, I mean, if I'm wrong, I'm wrong. This is an academic setting. I mean, if I didn't get the essence of your presentation, yes.
You are right, actually. You are right in what you said. But let me walk my thoughts through.
Briefly.
I'm kind of a simple guy. And my question is, what is the most important thing that the Supreme Court of Ghana is asked to do? And to answer that question, we go to our Constitution. And the starting point is the preamble. And the preamble, if you read it carefully, within the background of legal jurisprudence, is essentially a preamble that asks us to promote the rule of law. Of course, the meaning of the rule of law is highly contested. But when distilled to its essence, it means that nobody can exercise power anyhow in this republic. And the Supreme Court of Ghana, it starts with ensuring that people entrusted with public power, especially, even private power, they don't exercise it in a way that contravenes the Constitution. Okay. But because the government is vast, the executive, legislature, the judiciary, even the citizens, I focus only on the executive. Yeah. And I walk through how the Supreme Court has pronounced its judgments on this. Of course, like Richard Posner, the American legal scholar, said, if we had a higher court more than the Supreme Court, they will sometimes overturn the decisions of the Supreme Court. Another one will do that. So the Supreme Court can be wrong sometimes. Yeah. It therefore is in the place of legal academics like us to assess whether what the Supreme Court has done is right or wrong. And this has not been done in the last 30 years. There are only 2 books, if I'm wrong, please correct me. One by Justice Kofi Titiba. When he retired, he gave a reflection on the Supreme Court. And then Dr. Bimpong Buta also wrote a book. He's not even a judge. Bimpong Buta's book is more credible because he wasn't on the bench, so he can look at the decisions of the court independently. But Titiba was part of it, so But so far, of course, we've written articles here and there about it. But there's no comprehensive work on the Supreme Court, and for me, that is a worry. And 2, the Supreme Court is not just tempering power for the sake of tempering power. It has a telos, it has an end, and that one of them is democracy or good governance. And I'm asking, what the Supreme Court has done, has it promoted good governance in Ghana? And I based this second question on an article by Farid Zakaria in 1997, The Rise of Illiberal Democracy. And the question is whether Ghana is an illiberal democracy. Illiberal democracies are basically democracies that hold elections. After elections, the government do whatever they please. In 1997, Farid described Ghana as an illiberal democracy, and that was probably understandable. Today, looking at our context and the way things are happening, when was it? The soldiers went to Ashama and this was displayed there, and a bit of these things. I'm wondering what he particularly, because his view is very popular these days, what he predicted in 1997 is happening. What he would think of Ghana's democracy today, whether it be illiberal democracy or not. And I don't have answers to that. But myself, of course, whether Ghana is an illiberal democracy or not, I have my own views on that. But that, I don't know what this important author said in 1997. It's very troubling. That was the point of my paper. Thank you very much.
Thank you. Susanna.
So the Dean's question to me is, what path should we chart for voter identification in the 2024 presidential and parliamentary elections? I'm of the view that the current CI 126, in that regard, is fine, just as it was used in 2020. I'm of the view that it still can be used, and so with regards to voter identification, I really don't think that it should be amended.
All right. A very diplomatic answer.
I was just going to say the same thing. Yeah, thank you very much, Dean. So our paper basically was to scrutinize the way the Supreme Court has been applying its jurisdiction under Article 131. Now, if you look at 131, there is A and there is B. A talks about where the question of interpretation arises in a court below the Supreme Court. And then B talks about where there is an allegation that a legislation has been made in excess of the powers that the Constitution has given. Now, Cletus's presentation, which he explained, basically was that the Supreme Court has used only one test to apply to the 2 circumstances. And our proposition is that, 1, they shouldn't use one test to apply to the 2 situations. They should develop 2 different tests because they are 2 different issues. Now, the reason why you need to go back to Riakutu situation and the correction that
the Justice Akufo-Addo CJ committee, which drafted the 1969 Constitution, sought to make to the real Koto situation, to understand the importance of the arguments we have been making. They have lived under a constitution where they experienced the dangers of not having the power to declare a legislation which is obviously wrong, ultra varies the constitution. And they've also had the experience of knowing the difference between interpretation. Now, the challenge that Dr. J.B. Dankwa faced before the court was the inability of the court to accept that Parliament could make a law in excess of the powers that the Constitution has given it. So when they were drafting the 1969 Constitution, they were very emphatic. If you read the memorandum, they made it extremely clear that these are two different situations. So in the 1969 Constitution, as Cletus pointed out, they put in there that whenever there is an allegation that a legislation or a law was made in excess of the courts of the powers that the Supreme Court has given, powers that the Constitution has given, the Supreme Court should have the exclusive jurisdiction to explain and deal with that issue. Now, the same provision was repeated in the 79 Constitution and then in the 1992 Constitution. Now, what we have seen over the years is that the court has just been using only one eye instead of using two eyes for the two different situations. Used one hammer to solve the two situations, and that hammer they picked from Ex parte Acosta, which stated the grounds on which a lower court ought to refer a question of interpretation to the Supreme Court without ever having any attention or paying any attention to a situation where an allegation of that a law has been made in excess of the court's powers. Now, our research shows that they have been using this one hammer to deal with the two. And the case that Cletus cited, that's a J and against the IGP. So this was a case where the allegation was that the Rules of Court Committee has made a rule which was in excess of its powers. Now the case went to the High Court. So the applicants were asking the High Court to refer that question to the Supreme Court in accordance with Article 130, 1B, not A. Now, the High Court cited a lot of the Supreme Court cases, which was on grounds A, and dismissed the application and dismissed everything. So the parties, referred the matter to the Supreme Court. That the High Court acted in excess of its jurisdiction by dismissing the question. So the Supreme Court should consider it. Then guess what? The Supreme Court took the same hammer which the High Court used and applied it and also dismissed the matter that this is a question. If the High Court has jurisdiction to refer, then it also has jurisdiction not to refer, and therefore you cannot come for judicial review. So our view, our proposition is that if this continues, we may end up in Ria Koto situation one day where before someone gets justice, he would have to wait from the High Court to the Court of Appeal to the Supreme, which can take you that journey can take you about 3 years to make. So we basically are saying that it is time for the Supreme Court to be a bit more critical on these two distinctions, in order not to forget the history behind the provision and where we are coming from. It was Justice Wendelholm who said something. He says, it is one of the misfortunes of law that ideas become insisted in phrases and thereafter for a long time cease to provoke further analysis. So lawyers we are often victims of this. So for example, if you go to court and they ask you to raise your hand to take the oath, do you know why you have to raise your hand? Nobody has bothered to find out. But the history is that early, I think 1500s, when you commit a crime and you are convicted, they brand the offense in your palm. So for the judges to see whether you are known or you are a former convict, you have to raise your palm for them to see if you have the. But today we still do it with no one actually thinking why we do it, and that is how law is. So our caution, well, not caution, but our plea to the Supreme Court, submission to the Supreme Court, is that they probably should be very much critical on this, so that we do not lose a very important history which we have all suffered one way or the other. Thank you very much.
Thank you. Thank you very much, Justice, and all the panelists for your questions. So now we'll throw it to the audience. I'm sure some of you have questions. So there's a microphone that's going around. We'll take about 3 or so questions. You can direct them to whoever you want to direct it to, or to the entire panel, and then we'll get their responses.
Thank you very much. So I'm Emanuela Dorin Kofi from the Ghana School of Law. And my question is directed to Mrs. Susanna Efutu on the issue of citizenship, so specifically on dual citizenship. So when you look at Article 94(2)(a) of the Constitution, one cannot be a member of Parliament if you owe allegiance to another country. Now, when you come to the Act 591, you are allowed to hold a dual citizenship. So my question is that upon a purposive interpretation of Article 94(2)(a), can one say that, is it right for us to say that if a member of Parliament or an aspiring member of Parliament holds a dual citizenship, that person automatically owes allegiance to another country, and so he or she cannot contest for the position of a member of Parliament? I think it's a critical area, because that same provision is not given to the President under Article 62. You just see that he's supposed to be a citizen of Ghana by birth, and even for other topmost political leadership in Ghana. So why is that provision given for the member of Parliament, that you shouldn't have held or owed an allegiance to another country? And what is the interpretation of that particular statement? Thank you very much.
Hello. Yes, my question is to Madam Susan. I thought that with the judgment in NDC versus AG, I was a bit convinced that looking at the birth set, it did not kind of guarantee citizenship enough, because by looking at the provision in there, a person born in the country by non-citizens are not citizens, unlike exist in other countries. And so people, and there is no guarantor system in there when people are providing information for the acquisition of the birth set. So then it's easier for people to acquire the birth set just by giving birth and providing the information that, oh, this is my mother's name, this is my father's name, is a Ghanaian, nobody checks it. And so it makes sense to me. In that the court is saying that the guarantor system is the best system to check for citizenship, by also allowing the use of the passport at that time. It is confirming sin. So, because you made the argument that the birth set is then also used to acquire a passport. But in the acquisition of the passport, you realize that there is still some form of guarantor system in there, by allowing somebody in court who is deemed to be of a certain high standard in society to confirm your application for the passport. So another addition to the guarantor system had been applied there. So to my mind, the Supreme Court was saying at that point that the only system it kind of recognizes is the guarantor system. My only worry right now is how come they are seeking to take away the guarantor system completely in this ID issue. Thank you.
Thank you. My name is Emmanuel. The question is to Justice Tromsai and Cletus. I want to find out, how would you differentiate review from supervisory interpretation and enforcement jurisdiction of the Supreme Court?
So my dear lady, I can't remember your name. Emanuela, great. So we're just going to walk through a few provisions on your question. So you are asking about dual citizenship, and you're saying that why does Article 94(2)(a) say that if a Ghanaian has another citizenship in addition to his Ghanaian citizenship, he can't be a member of parliament, but you don't see that prohibition applying to other important positions, if I'll paraphrase your question, right? So we'll look at some provisions in our Constitution and then the Citizenship Act, all right? So you are familiar with Article 94(2)(a), so I wouldn't belabor that point. But you must also look at Article 78, all right? So if you have a Constitution, you can look at Article 78. I will read it out because I have one here. Article 78 says, ministers of state shall be appointed by the President with the prior approval of Parliament from among members of Parliament or persons qualified to be elected as members of Parliament. All right, so straight away you can see that even to be a minister, to be part of the executive, you need to meet the standard, the requirements for a parliamentarian. All right, and then when you check also for the executive to be a president, it's the same standard applied. So it's just an extension of Article 94(2)(a) being applied to all, to executive members, the presidents, cabinet ministers, and parliamentarians. So there's no exception, there's no bias. All right. Now, if you check Article 8, now we know Article 8 has been amended by the Constitutional Amendments Act, Act 527, which we find on the front page of the Constitution. Now, if you check that amendment, first, Article 1 of Act 527 tells us that on the issue of dual citizenship, a citizen of Ghana may hold the citizenship of any other country in addition to his citizenship of Ghana. And then subsection 2, or let me say clause 2 says, without prejudice to Article 94(2)(a) of the Constitution, no citizen of Ghana shall qualify to be appointed as a holder of any office specified in this clause if he holds the citizenship of any other country in addition to his citizenship of Ghana. And it gives us a whole list: Ambassador or High Commissioner, Secretary to the Cabinet, Chief of Defense Staff or any other service chief, Inspector General of Police, Commissioner for SEPS, Director of Immigration Service, and then the G says any office specified by an Act of Parliament. So straight away we can see that it's not just being a parliamentarian or being a minister or being a president. For all these things you can't hold if you are a dual citizen. And then the list is further extended in section 16(2) of the Citizenship Act, Act 591. So there's a whole list of offices that you can't hold. Does it equate to holding allegiance to another country? All right, so when I started my presentation on acquisition and proof of citizenship, I gave a definition of citizenship from the Free Legal Dictionary. And to paraphrase that definition, you realize that technically citizenship is a bundle of rights and privileges. It's a bundle of rights and privileges that is accompanied by obligations. So, it becomes technical and dicey when you owe that bundle of rights and obligations to more than one country, especially when you want to serve in a sensitive position. All right, so that's my answer to you on that. And then to the gentleman who was trying to justify why a birth certificate should be excluded. The thing is, when you're trying to get a passport, you're asked to tender a birth certificate. And you don't necessarily have to do a statutory declaration or to use a guarantor process when you have a birth certificate. I can say this on authority because I have gotten passport for my children, and their birth certificate was all I needed to tender, really, at the passport office. That was it. I know there are guru boys in the system who tell people that, oh, you have to add, what do you call that thing? The one, the Commissioner for Oath, affidavit or statutory declaration, but it's not required. And if you just go with a birth certificate, you would get your passport. So that's my confusion with that. All right. You want to clarify your position? Yes, sir.
I meant the application form itself, requiring, say, a pastor or a lawyer to endorse, to give an endorsement on the form for you.
Okay.
That's what I was referring to as some form of guarantor system.
Okay.
Yes,
but when we use the guarantor system, when we're talking about this whole process, we need to use it advisedly because it has a special meaning within this context, you understand? Because within this context, the guarantor system applies to the situation where, for example, you don't have a national identification card, but you know somebody who has. So the person is going to vouch on your behalf. And then we have to, I think this is also coming back to the question that Dr. Ajimambudu asked me, that with regards to that statutory declaration that somebody does for you, which is the guarantor system, it is governed by the Statutory Declarations Act. Really, if the person lies, the person can be, in danger of perjury. All right, so that's how serious it is, which is why I'm of the view that CI 126, in that regard, really is as good as it is and really should not be amended, really, in any form or shape. All right, thanks.
Yeah, thank you very much. Before I answer our question, I would like to give a few comments on the other. Yeah, so the issue about birth certificate. So the birth certificate contains certain information. So it contains particulars about the person holding it. So it contains your father's name and nationality, your mother's name and nationality. Now, when the question who is Ghanaian is asked, the law says that if at least one of your parents is Ghanaian, then you are Ghanaian. That is how come the birth certificate is evidence of your nationality, because it will contain information about your parents and their nationality. So you can know from looking at the birth certificate if the bearer is Ghanaian or not. Now, the question, the issue you are putting across, official documents, the law says, are presumed to be what? Regular and proper. So, if the person who questions the validity of the document, who has the burden to what? Prove that something else other than what's on the paper is what the situation is. So long as the document has not been set aside, it is deemed to be what the situation until so that is how come and there is on the dual citizenship and allegiance, there is a very good English case on this matter. It's called Joyce versus DPP. Joyce, as in the name Joyce. Now, Joyce was he was an American who had a British, nationality passport, but during the World War II was working for the Germans. At the time he was working for the Germans, he was in Germany, and then he was arrested later and accused of of treason. So the question in the case was whether he owed allegiance to Her Majesty's, that's Britain. Now, you cannot be convicted of treason unless you owe allegiance. That is it's only people who owe you allegiance who can commit treason against you. If another person who doesn't owe you allegiance, he cannot commit treason. You can charge him with another offense. Now, so at Joyce is a man. Joyce's trial, the question was whether he owed allegiance to the crown. Now, the only way they showed that he owed allegiance was that he was, at the time, resident in England. So, by that, even though, there were two grounds. At the trial court, he was said to have a passport and also resident in the UK. Now, when on appeal, he proved that his passport had already been, had expired and he never renewed it, so that ground was left. And the only thing left was resident. Now, the question that the House of Lords held that he owed allegiance even without the passport by merely being resident in the UK, because when you are resident in a country, that country owes you some duty. In return of that, like Susie said, you also have some obligations that you owe anyone who is protecting you. And when you use that privilege of living to, so the question of allegiance is also embedded in your passport and in your citizenship and everything. That is why the courts keep saying that anyone who has a passport of another country is deemed to owe allegiance to that country. Now to our own question, which is the difference between the interpretation jurisdiction, the supervisory jurisdiction, and the review jurisdiction of the Supreme Court. Okay. Cletus has done justice to interpretation jurisdiction, which is that the Supreme Court is the only court that has the power or the jurisdiction to interpret the Constitution. An interpretation may arise in the grounds that ex parte accosa listed. So that is pretty much straightforward. Now, review jurisdiction is when the Supreme Court itself has given a decision either without taking note of a very essential point of law or a very essential fact. Then the person against whom the decision went may, within 21 days, would apply to the court to correct that. Now, to correct that, the fact that there's an error doesn't mean that the court will, you are entitled to review. You need to show that the error, if corrected, will turn the decision the other way. You get the point. That is why if you read all the cases for review, so the review is not to say that there's an error or no error. There can be an error, but if the error will not result in the decision going the way it had gone, the court will not grant you your review jurisdiction. Now, the other one is the supervisory. So the Supreme Court has the supervisory jurisdiction over all the other courts. I mean, let's say the superior courts, because the High Court has supervisory jurisdiction over all the lower court. So we will say that the Supreme Court supervisory jurisdiction over the Court of Appeal, the Regional Tribunal, and the High Court. Now, this jurisdiction means that when a court is exercising its power, that's the court below the Supreme Court, when they are exercising their power, they may commit several types of errors, but it's only two errors that will entitle you to seek the Supreme Court supervisory jurisdiction. One is error which is patent on the face of the record. Error patent on the face of the record means that there is some well-established point of law which everybody who is properly sitting as a judge should know, and that judge omitted or made an error in respect of that position of law, then the court will overturn it. The second one is that the court has acted out of jurisdiction. It means that it didn't have jurisdiction. That we call it jurisdictional error. It means that the issue you are handling, you have no power to handle it at all, yet you have gone ahead to. So a typical one is when a court below the Supreme Court purports to interpret the Constitution. It has no jurisdiction to interpret the Constitution. So when it ends up doing that, the Supreme Court will issue certiorari to quash that decision. And Cletus was explaining part of our research is what Cletus explained, that the question whether a court has jurisdiction or not is not subject to the outcome of that court's decision. So if I don't have jurisdiction to interpret the Constitution, then whether I interpret it correctly or wrongly doesn't even come up. I don't have the jurisdiction, so I cannot even be seen to be interpreting, let alone interpret it correctly or wrongly. Now, where we have identified the challenge is that over the years, if you take all the cases that the Supreme Court has actually decided that the judges below made a jurisdictional error or interpreted the Constitution, there were only situations where the outcome, the decision of the court below is against what the Supreme Court would have decided. So then it creates an impression that the cat is rather placed before the horse, in the sense that they look at the decision, do we agree? If they agree, they said the court, the lower court did the correct thing. It didn't go beyond its jurisdiction. When they look at the decision and it's something that they don't agree with, then they will say, no, the judge erred. So our proposition is that it shouldn't be the case that the only time that the court will say there's a jurisdictional error is when they disagree with the outcome. It should be possible for the court to say there was a jurisdictional error, refer the matter to themselves, and still come to the same conclusion as the court below. Yes, you may argue that it may be judicial economy and all that, but there is a reason why the Constitution reserved that jurisdiction to the Supreme Court. And the Supreme Court itself has stated in a number of cases that it is jealously guarding that jurisdiction. Yet we find out that they actually are not jealously guarding it. They only quash cases when the outcome is against what they would have preferred. And we are saying that it is important that the court would be true to its word by jealously guarding that jurisdiction. Oh, okay. Yeah, sorry. There's another ground for judicial review.
What's the microphone? Yes, Council Chairman wants to.
Just a footnote, Mr. Rapporteur. There's a reason and a history for dual citizenship. Let me state this as simply as I can. You know, most Ghanaians had gone for greener pastures, so-called. And before they could work, say, and what jobs were they doing in Italy? Plucking fruits and so on. Doing something. In America, what did they do? Washing dishes and so on. Contributing to the economy there. We found that as diplomats. At that time, I was the director of the legal section here. That most Ghanaians were renouncing their Ghanaian citizenship. Why? In order that they would acquire American citizenship. In order that they will acquire European citizenship. So what some of us did was to start questioning the whole thing. Why is it that Ghanaians, we have to go. They've gone to work. Why should they simply renounce their Ghanaian citizenship by birth? And Paul said, Civis Romanus sum. So I'm entitled to justice in Rome. You remember Paul? Mm-hmm. All right. So some of us made the argument to government. This is how we work in the civil service. We didn't have the idea of citizenship. But we started saying that, listen, government, why don't we make it possible for our brothers and sisters who've been working years and now they simply renounce their citizenship by birth so that they would acquire the citizenship where they've worked for years? So the whole idea of citizenship, frankly, is a matter of policy. Dual citizenship, I mean. It's a matter of policy. It's new. That other nations have dual citizenship. It's something recognized by international law. So why don't we have dual citizenship? And since we did that, it's been possible for Ghanaians there to acquire citizenship with their place of residence, country of residence, and still retain their citizenship by birth. It's a practical thing. But you see, you won't be told these things. This is how it came about. And since then, everybody is happy. Now, as to the question whether a dual citizen can, again, be a minister or an MP, again, it's a matter of policy. And frankly, it comes to a question of loyalty. You can't be the ambassador of Ghana to the United States when you also hold dual citizenship of the United States. It's as simple as that. Common sense. Common sense. That is how we work. Thank you.
All right, let's take a few more questions and then we'll wrap up the session. Yes.
Hello, my name is Grace Frederica Richard, final year student here at GIMPA. Yeah, so my question is to Justice Rimside, please. Doc, please, I want to know about the referral that you spoke about. Is it only limited to appeals, or it also has to do with the judicial review? Because there was no mention of that. So please, can you comment on that? Thank you.
All right, is there any other question? There's a question here. Okay, there's one here and then there's one towards this end as well.
My name is Debbie from Ghana Civil Aviation Authority. My question is to Cletus and Justice. First of all, thank you for the education on the end-all debate with regards to the reference jurisdiction of the Supreme Court with regards to constitutional interpretation. And I'm curious to know, how does a court come to the conclusion that there is an interpretation issue or not without first interpreting? I'm just curious to know, because I think that before coming to that conclusion, there is an attempt at interpretation. So I want to know. Thank you.
The last question on this end. Okay, two more. Okay, yeah.
Thank you. My question is addressed to Mrs. Susanna Afoki. And I want to find out, how is it possible for the administrative officials to exercise the discretionary powers judiciously, as in without bias? Do they have checks and balances? If so, what are they?
Thank you very much, Dean. That is my name. Madam Susanna, may I please, if you can please help me with this. I want to know why anytime a CI is sent to Parliament, before Parliament will pass into law, they have to wait for 21 days before they will pass into law. I want to know the reason why. Thank you very much.
All right, so let's briefly deal with the issues and then we'll wrap up in a few minutes. So, Cletus and Justice, if you can address.
Okay, so let me do with the second question. Again, you always have to be cautious. And I made that point. In fact, there's no God I said that it is dangerous for you to presume that the question there's no interpretation at all. Now, but then again, when you come to judicial economy, words have ordinary meanings, and they may assume secondary meaning depending on the context in which they are used. You may be right that an attempt to decide whether the question calls for interpretation or not may itself be a little bit of you may require a little bit of interpretation. But that is why our submission was that if you are applying the ordinary meaning of the words without going to the second and third stages of the MOPA, then at that stage there will probably may be no need to refer, and that is why the standard set in the Espata Akosa case becomes relevant. In fact, in a more recent case, the Supreme Court said even when parties put rival meanings to the words, the court has to still be cautious, because some people can put meanings which are unnatural meaning just for the sake of pushing a referral to delay case or to do some other matters. And so even when the parties are putting rival meanings to the provision of the Constitution, you will still have to be very cautious. So our submission is that if you are ending at the ordinary meaning of the words, then you probably may be in the line of my can by just applying the provision without going beyond that. And in that case, there may not be any need to refer. But if you are moving away from that ordinary meaning and going to stage 2 or stage 3 of MOPA, at that stage, then you may be overstepping your jurisdiction. So that is the test that we want to run with.
Yeah. To the second, that's the first question about whether the referral jurisdiction applies to only appellate or judicial review matters. Yeah, so the referral provision is straightforward. It says whenever a court, other than the Supreme Court, is dealing with any matter, and there is a question as to interpretation of the Constitution, that's A, or B, where someone is alleging that a law has been made in excess of the powers given, you must refer to the Supreme Court. What this means is that whether you are in an original case at the lower court, district court, circuit court, high court, court of appeal, any other court apart from the Supreme Court, and any of these questions come up, you have no business exercising you don't have that jurisdiction. You have to stay the proceeding, refer to the Supreme Court. The Supreme Court will give you an answer, then you will now use the answer to what? Resolve the issue before you. So if you are, let's say you are even in a divorce situation, and there's a question as to whether Article 22 has this particular meaning, the judge who is handling the divorce, whether in the High Court, would have to stay the divorce proceeding, refer that question to the Supreme Court to answer. The Supreme Court will give you an answer, then you take the answer, and then you apply the answer in the divorce proceeding, then you conclude the matter. So it applies in every court, every matter, apart from matters that are happening in front of, before the Supreme Court itself. Thank you very much.
Let me just add that. So even on appeal, if the matter goes before the Court of Appeal and such a question arises, the Court of Appeal is not at liberty to just pronounce on the matter and leave it. They are also bound to refer. So if you look at YEBOAH versus PNT Corporation, the High Court had attempted to strike out a provision in the Communications Act as being unconstitutional, which was wrong. It was the essence of their jurisdiction. The Court of Appeal, when the matter came before them, said that the High Court was wrong and then set aside the decision of the High Court. But they also ended there. The Supreme Court said no, the Court of Appeal was also wrong. After arriving at that decision that the High Court was wrong in making that enforcement by striking out the decision, they ought to have referred the matter to the Supreme Court. So it can arise in any stage, even when the matter is on appeal. It still has to be referred once that issue arises.
Okay. So I'll start with my lady's question on how administrative officials can properly exercise their powers. And yeah, I think that's the paraphrase of her question. Now, when we look in our Constitution, Article 23 tells us that administrative bodies shall act fairly and reasonably, and that people affected by their decisions shall have the opportunity to take, that case before a court or tribunal. Now, what this means practically is that they must use what we call the principles of natural justice. Principles of natural justice means don't come to a decision without hearing the other party, for example. So we've had many cases of administrative officials going before a court for review and being overturned. We have an English case, Cooper versus the Wandsworth Board of Works, where the Act gave the part to the local authority to pull down somebody's building. But before they pulled down the person's building, they didn't even give the person a hearing. And when they went before the English courts, they said, you have the power to pull down his building all the same, but it wouldn't have spoiled anything if you had just heard him out, all right? And if we come to Ghana, we have cases like Awuni versus WAEC, West African Examination Council, where Awuni was alleged to have been involved in examination malpractice, and his examination results was cancelled without a hearing being given to him. So the case was taken on, I believe it was Professor Atiguba, who was his lawyer, and said that, this is a clear case of lack of natural justice. He was not heard, and on that account, the court agreed with him, and the decision of WAEC was overturned. So that is how practical, they can be. Just, apply the principles of natural justice. Give people an opportunity to be heard, whether it so applies. All right. Now the gentleman at the back asked about why, where a CI is taken to Parliament, they have to wait for 21 days. It's because the Constitution requires it. If we look in Article 11, Clause 7, it says, any order, rule, or regulation made by a person or authority under a power conferred by this Constitution. So order, rule, or regulation is LI and CI, all right? Under a power conferred by this Constitution or any other law shall A, be laid before Parliament, B, be published in the Gazette on the day it is laid before Parliament, and C, come into force at the expiration of 21 sitting days after being so laid, unless Parliament, before the expiration of the 21 days, announce the order, rule, or regulation by the vote of not less than 2/3 of all members of Parliament. So it's just in fulfillment of a constitutional provision. All right, thank you.
So I'll ask one last question to Prosper, then we finish, and this has to do with oversight over executive authority. So from your work and from your research, how do you think will be the best way in which Parliament's oversight responsibilities, I know you're talking about the judiciary, but how do you think that Parliament, which is another important institution, arm of government, will their power in terms of oversight over the executive, in particular the president, because in recent times we've been hearing conversations about the expansive powers given to the president, and you allude to some of it in terms of the judiciary in serving as a check on exercise of executive authority. Do you think Parliament, as we have it under our Constitution now, has played and can play any meaningful role in terms of checking the exercise of executive authority or executive power?
I'll be very brief with my response. In two ways. One, appointments. So Parliament approves the appointments of the executive, especially the president. And the last time I checked, the approval of the appointment of some 6 people are pending. I don't know what the reasons are. So it's one way. And this morning, before the conference started, there was a debate over, I believe, Article 181.5, requiring any contract, international agreement, a contract to be approved by Parliament. There's a view that it should be looked at. I don't think it should, because these agreements involve a lot of money. And if Parliament is allowed to prove them before they are approved, that should be very good. So those two. Thank you.
Right. Thank you very much, Prosper. I think we should give all our speakers a big round of applause for an excellent job done. All too soon, we've come to the end of panel discussions for day 3 and also for the conference. And as rapporteur for the conference, I have the privilege of presenting to you our final report. Earlier in the morning, we presented the first 2 days, day 1 and day 2. So I'll briefly present the third report on the day, and then the communique which we will be issuing at the end of this conference as well. So today we focused on the vital role of the courts. We focused on the vital role of the courts in the 1992 constitutional dispensation. 2 sessions were held today. The first was an interactive session reflecting on the proceedings of the previous 2 days, and the third was the one that we just had, the panel discussion, which focused essentially on the judiciary in Ghana under the 1992 constitution. So for the first discussion, the first discussion was an interactive session, and then there was this panel discussion. The first speaker, Mr. Prosper Andre Batinge, emphasized that the Supreme Court has played a pivotal role in promoting the rule of law since 1993 by controlling how executive power is exercised. Mr. Batinge began his presentation by highlighting the significance of preambles in constitutions generally, and specifically in Ghana's constitution, as well as the jurisdiction of the Supreme Court of Ghana. He argued that the preamble directly references the rule of law and other fundamental elements such as freedom, justice, accountability, sovereignty, human rights, and the right to vote. Additionally, he pointed out that the Supreme Court has exclusive original jurisdiction and mandate over these matters. He noted, however, that the court seeks to limit the executive's powers within the domain of the Constitution and Ghana's laws rather than interfere with the government's lawful policies and actions. He concluded by discussing the concept of liberal democracy and agreed that Ghana was an illiberal democracy. The second speaker, Mrs. Susanna Afutu, discussed citizenship in Ghana and expressed dissatisfaction with the means of proving one's citizenship. She opposed the idea, for instance, that a national identification card should be the sole means of voter verification, and suggested that administrative bodies' discretionary powers should be restricted. Finally, Mr. Cletus Alenga and Dr. Justice Shremsai focused on the referral jurisdiction of the Supreme Court of Ghana. They discussed the Supreme Court's original jurisdiction under Articles 2.1 and 130 of the Constitution, which entails interpreting, enforcing, and deciding against the misuse of power by other entities. According to them, the Supreme Court's discretion in matters of interpretation should be exercised robustly but carefully, and they argued that the interpretation and enforcement jurisdictions are not mutually inclusive, and that if care was not taken, we will be sent back to the days of old, for instance, during the days of Riakoto and 7 others. And that is the third day's report. So we've come to the end of the conference, and as tradition demands, a communique will be issued, and I have the privilege to briefly run through this, which will also be issued to the media as at the end of this proceedings. So, communique issued at the end of GIMPA Law Conference, and the theme, the 1992 Constitution of Ghana 30, taking stock, assessing progress, and reflecting on the future, held at the Ghana Institute of Management and Public Administration from the 14th to 16th March 2023. So the preamble. The GIMPA Law Conference took place at GIMPA from the 14th to 16th March 2023 on the above theme. The sub-themes were 30 years of multi-party democracy, challenges and prospects, the economy and financial management in Ghana since 1993, human rights under the 1992 Constitution, miscellaneous constitutional questions, management of natural resources under the 1992 Constitution, women's rights and the rights of persons with disabilities, constitutional review and amendment of the 1992 Constitution, the interpretation and enforcement of the 1992 Constitution, contribution of the judiciary to constitutional development, and finally, the judiciary under the 1992 Constitution. Observations. The participants observed the following. 1. That our 30-year-old Constitution has been the basis upon which the administrative bodies of the government have applied principles such as the rule of law, constitutionalism, separation of powers, checks and balances, and the promotion and protection of fundamental human rights of the citizens. 2. That the Constitution is the supreme law of the land, and all other arms of government or persons are subservient to it. And 3. That as a relatively young Constitution, there are certain necessary changes as well as better ways the Constitution can be implemented. So to the recommendations. The participants at the 2023 GIMPA Law Conference recommend the following. 1. As a nation, we must embrace technology and its creator systems as opposed to totally abandoning that idea due to foreseeable failures that can be prevented. 2. Private prosecution of corruption-related offenses should be considered to help the state fight corruption. 3. Article 1815 of the 1992 Constitution should be seriously looked at, as it doesn't seem to have been given full effect in the past 30 years. 4. The provision on the prohibition of coup d'etat or unconstitutional overthrow of the Constitution should be amended to expand what would constitute a suspension, an overthrow, or an abrogation. 5. We must consider a cap on the number of constituencies created, as well as the number of members of parliament, as this would help ease the pressure on the public purse. 6. We must also consider returning to the 1979 constitutional provisions on strict separation of powers between the executive and the legislature, so that a member of parliament cannot be a minister of state at the same time be a member of parliament. And this will help strengthen the institution of parliament to serve as a check on the executive. 7. The legislature, in enacting or amending new or old laws regulating natural resources, should take a look at the blueprint of the law regulating the management of petroleum resources. 8. We should urgently pass the Affirmative Action Bill, ratify the Maputo Protocol, and always make provision for persons with disabilities in our laws. 9. The process of enacting executive instruments should be amended to include a process that reflects the principle of checks and balances. And 10. The discretionary powers of the administrative bodies such as the Electoral Commission should be carefully circumscribed. The Faculty of Law, and in particular the Steering Committee of the 2023 GIMPA Law Conference, takes this opportunity to appreciate all persons who graced the event, especially our distinguished speakers who have highlighted the strengths and weaknesses of the Constitution 1992 and made proposals for reform. Finally, we thank the Chairman of the Governing Council of GIMPA, Kofi Darko Asante Esquire, for being with us for all 3 days and for his insightful contributions to our discussions. Thursday, 16th March 2023, at the Ghana Institute of Management and Public Administration, GIMPA. Thank you all for your presence. We appreciate your time. And if Mr. Chairman, if you permit me, I will say the conference has come to a close. Yapong. There are some refreshments outside, so we'll respectfully wait as the chairman of the Governing Council of GIMPA and our presenters take their leave, and then the rest of us can proceed. Thank you so much.